The author of this legislation.
Gentleman is recognized for 6 minutes.
Ask for unanimous consent to revise and extend my
Without
remarks.
objection, so ordered.
I thank the gentleman from Texas for yielding. Mr. Speaker, I rise in support of H.R. 2679, the Public Expression of Religion Act. This legislation would allow Establishment Clause cases to go to court, unfettered by fear or coercion on the part of the defendant. And as an aside, I want to thank the gentleman from New York for clarifying a position earlier made by that side of the aisle when it was suggested by the gentleman from Texas and the gentleman from Massachusetts that somehow this bill would actually affect free exercise cases. But as the gentleman pointed out, the gentleman from New York pointed out, this bill does not address free exercise cases. The Public Expression of Religion Act would amend 42 U.S.C. sections 1983 and 1988 to prevent the mere threat of the use of the legal system to intimidate communities, states, and groups like the American Legion into relenting without ever darkening the doorstep of a federal courthouse. I first introduced the Public Expression of Religion Act in the 105th Congress after I realized that the mention of attorney's fees in these kinds of cases were jeopardizing our constituents' constitutional rights. An example of this was in 1993, when the Indiana Civil Liberties Union, which is affiliated with the American Civil Liberties Union, mailed a letter to all the public educators in the state of Indiana. In this letter, the ALCU informs the educators that should they support a prayer at graduation, the ALCU will sue both the school and any individuals who approve the graduation prayer. The letter plainly states that the ALCU will win and that whoever is sued will have to pay not only their attorney's fees, but the ALCU's attorney's fees as well. These threats to teachers who are highly unlikely to be able to pay their own attorney's fees, let alone the exorbitant attorney's fees of the ALCU, make it very likely that educators would capitulate to the Indiana Civil Liberties Union before even checking to make sure that the ALCU has their facts right. What makes this even more difficult for states and localities is that the jurisprudence in Establishment Clause cases is about as clear as mud. Different districts and even the Supreme Court itself flip-flops on issues. For instance, last year, the Supreme Court handed down 2 Ten Commandments case decisions on the same day, with a different decision in each. In the Van Orden case, the court applied the Marsh test of historical perspective to determine that the Ten Commandments in a public venue in Texas was constitutional, while the McCrary case used the Lemon test to determine that the Ten Commandments in a public venue in Kentucky was unconstitutional. Clear as mud. Our constituents who are being threatened with these lawsuits know that even if they are right, they will still have to pay their own attorney's fees to take the gamble that the court will muddle through one more time the jurisprudential mess of the Establishment Clause and come out on their side. If the court chooses to use the Marsh test, they might win. If the court chooses to use the Lemon test, they might lose. It's a toss-up. Unfortunately, many of our constituents do not have the means by which to set aside a small fortune each year to defend their constitutional rights against intimidating liberal organizations. Nor do they look kindly on the fact that their constitutional rights have become subject to the whims of unelected judges. But, Mr. Speaker, that issue is for another legislative day. Regardless, many do not wish to roll the dice to have their day in court, so they capitulate to these organizations and their often questionable pronouncements of what is or is not constitutional. A majority of the cases the ALCU and its affiliates represent are facilitated by staff attorneys or through pro bono work, so any attorney's fees awarded to them is icing on the cake. It's a win-win situation for them right now. On the other hand, states and localities have limited resources with which to fight court battles, thus another reason that they are capitulating before they even go to court. This was the case recently with Los Angeles County and their seal, and the gentleman from Texas referred to it. The ALCU threatened to sue LA County if they did not remove the tiny cross from the county seal. The cross symbolized Los Angeles County's birth as a Spanish mission town. The county was forced to choose between paying to change the seal or paying to go to court and possibly pay exorbitant fees to the ALCU. In the end, the LA County supervisors, in a 3-2 vote, decided to ignore the will of the people of Los Angeles County and pay to change the seal instead of paying to go to court. They had been advised by their attorneys that if they lost in court, they would not only have to change the seal, but they would additionally have to pay attorney's fees of the ALCU. Mr. Speaker, I believe it's time to bring this extortion to an end. The Public Expression of Religion Act would make sure that these cases are tried on their merits and are not merely used to extort behavior via settlements outside of our judicial system. As the ALCU said at the end of their letter, quote, The ICLU does not enjoy litigation. We and you have better things to do with our time, end quote. I, for one, would like to make sure the ICLU has to think long and hard before litigating. And this would be the case if they knew they would actually have to convince a court of their twisted view of the Constitution. I urge my colleagues to support the legislation and yield back my time.
Gentleman yields back his time. Chair recognizes the gentleman from New York.
Mr. Speaker,